Okay. Oh, do I have my... Whoops. Let's get my audio working. We got audio. Always got to mess with something, right? Let's see here. Sorry. I'm going to reach over. You got to hydrate. And that is what I'm going to do to start this out. I'm going to get some water going in me. All right. So, I am looking. I brought you guys in because part of why I brought you guys in is that it's just been about a week. I've been very, very busy. I haven't had a chance to do a live, and I was like, I don't really have a plan. And I was sitting around, like, I started and stopped a live plan several times this evening or this afternoon, today, whatever. And I was finally like, you know what, just do it. So that's what we did, with absolutely no plan. Although I did set a timer, so I'm not here all night. But what I'm working on right now is I'm looking through this case, which this case is so long that, hey, Rebecca, how's it going? This is how long this case is, okay? The way that I print these cases out is I put 2 pages on each page, which does make them a little hard to read, but, I'm going to run out of paper otherwise. And I double-side them. So, I was trying to save paper here. And this case was so long that I still had to put it into 2 different... A stapler wouldn't fit. So I had to break it in half in order to staple it. It was that long. So, we're looking at this case that is... It's a weird one. And it starts out right here. I've never seen an opinion start with something like this before. The judge put this postcard at the top of it. Hey, Allison, how's it going? And the postcard says, 19th of June, 2025. Trump has pardons and tanks. What do you have? And it says, postcard dated June 19th, 2025, on file in chambers. I've never seen. Hey, it's good to see you too. I've never seen a judge do something like this before. So obviously it drew my attention a little bit because I was like, the heck's going on here? And one of the things that's happening, and I'm not entirely sure why, is that there is no... I love it! Rah! I love that. Is... that note, yeah, and the note... So the response to the note is, Dear Mr. and Ms. Anonymous, alone I have nothing but my sense of duty. Together, we the people of the United States, you and me, have our magnificent Constitution. Here's how that works out in a specific case. And so this is going to be our answer, I suppose. Thank you, Allison. And what is a little bit different about this case, just a little bit, is that unlike, I would say the majority of cases... Oh, thank you. I'm so glad. Thanks, Ken. Unlike the majority of cases, the finder of fact, the person who's going to look at the evidence and decide what actually happened here, is going to be the judge. Usually, that's a jury. And so the only way to have that be a judge, there's a couple, but generally the only way is for both parties to waive and decide they want the judge to be the finder of fact. Because there is a constitutional guarantee of a jury to determine questions of fact. But in this case, it's the judge. And so what that means is that, and this is how I split this case up because it was so long, it's 161 pages. The first Oh, wow. The stapler didn't even go through the first chunk. I didn't even realize that till now. The first 100 pages of it is just the judge determining what the facts were here and telling us what the facts in this case were. That is a little bit, like I said, it's a little bit unusual because usually you have a jury that does that sort of thing. So, and I'm trying not to get bogged down in 100 pages of fact finding here, but there is just so much going on here. And really what I want to get to here is the fact that we're finally getting to a First Amendment question here, which so many of these questions, these cases we've been looking at, have looked to me like First Amendment cases, or like they have a First Amendment element to them. And I was just kind of waiting to finally get to that question. And here it seems like we're finally getting to one of those big questions. And it looks like the judge just kind of skipped directly to it. Because so many of the decisions that have been made over the past, where are we now? 10 months, 9 months, whatever it's been, on their face, prima facie, on their face, facially, are based on the opinions, the opinions of a group of people. And I'm not making a value judgment there, and that's really important. I'm not making a value judgment here. They are explained as being facially opinionated. They're not pretending not to be, and so as a result, but we generally have not allowed that. We've never allowed that. And so why it's taken all of these cases so long to get to this question has been a little bit weird. I've been wondering why it's been taking so long for us to get here. So we're finally there, at least in one case. And this is a case where 4 people have been deported, or one way or another, decisions have been made about their immigration status based on their opinions. And the question is that allowed? And I've said to you guys before, I'm not good at predicting the future. I'm really good at predicting the past. I can tell you what things have looked like prior to today, and we'll see whether the courts decide to stick with that, whether the courts see this set of facts the same way that they look to me, that sort of thing. That's what I mean when I say I can't predict the future, I can predict the past. I can only tell you what the rule has been in the past and what the closest rule to what we're seeing here looks like for the past. I can't tell you how it's going to be interpreted for this. But here we have an interpretation, finally. And so this case, and like I said, we have to get 100 pages into it before we start even getting to the questions of law. And I'm skipping past standing. I know that Allison said, or it sounded like Allison may have already taken a look at this. This is, by the way, in my shared documents. I believe it's in First Amendment cases, if anybody wants to take a look at this. But I know a little bit about what's going on just because I've seen the news. I keep picking it up today. I printed it out. I was like, okay, I got to print this out. I know it's coming. Finally printed it out, and I've picked it up like 5 times, and it's just so bulky that I keep getting, kind of tied up in standing questions and things like that. So I'm jumping ahead right now to finally getting to the real meat of this question so we can talk about it. And by the way, if you guys are in here and you wouldn't mind tapping the screen, I would appreciate it, because we'll get some people in here. So we're finally getting to this question of viewpoint discrimination, which is the first count of this case. And viewpoint discrimination is what under the First Amendment is sort of where we draw the line between what is and is not allowed under the First Amendment. If you are restricting people's ability to communicate in some way, and remember, communication, speech, all very broad terms. Can you guys hear? It's another helicopter flying overhead. They've very, very broad term. But let's say, communicate, which can mean a variety of things. And you're generally allowed to restrict people's ability to communicate. You're not allowed to restrict certain people's ability to communicate based on their point of view. And that is where the big line is drawn, okay? And so if, in fact, someone was told, we have made a decision about, for example, your ability to remain in this country based on... That's a really low helicopter. Can you guys hear it? I don't know if you can hear it on the mic, but... based on what this person's opinion was, based on what this person's viewpoint was, that's generally in the past been considered not allowed. Okay, so let's take a look at what this judge says here, because this is the exciting case that everybody's been talking about. So, 2 preliminary questions must be settled before a plaintiff's First Amendment viewpoint discrimination claim can be analyzed. 2 questions, all right? Number 1, what First Amendment rights the non-citizens at issue here possess? Oh, I got a good one on this. And 2, what standard of review applies to the plaintiff's challenge to an ideological deportation policy implementing the president's executive order? And are they just going to answer this real quick? Okay, yeah. The first question is dealt with very easily, in part because the court has already addressed it and ruled non-citizens have at least a core First Amendment right to political speech without reprisal. So, can you talk about going through your favorite haunted house experience? Not right now, but we'll come back to that. So, I've been through this several times before, and I hate to be repetitive, but I'm going to go ahead and be repetitive anyway. The Constitution has nothing to do with you. The Constitution is about the government, right? The Constitution tells the government what to do. The Constitution tells the government what it can do, and it tells the government what it can't do. It doesn't tell you what you can do and can't do. Okay? The Constitution only tells the government what it can and can't do. It's essentially a contract that all of the states and people agreed to when they set up this government, that this is what we're going to allow this government to do and what we're not going to allow this government to do. So, when the First Amendment was written, what that First Amendment tells the government not to do is not to restrict people's freedom of speech, for example. It doesn't tell you that you can say whatever you want. It tells the government what they cannot do. Okay? And that is why it's so important when people ask about whether or not, for example, what did they say here? Whether a non-citizen has a First Amendment right. The answer is that the First Amendment is about the government, not the person. Okay? And that's why, we've talked about the 14th Amendment and due process rights and all this stuff. The government is about the Constitution is about what the government can and can't do. And so it's not about the person. Now, that does not mean that we have restricted the government in all situations. But these broad strokes, and that's kind of what they're saying here. They're saying it in a weird way, but this is essentially what they're saying. That there is a core First Amendment right to political speech, because what they're saying that broad stroke is that the government is broadly restricted from stopping people from speaking. The American government is not allowed to do that. And so it doesn't really matter which person we're talking about. If there's a person in America, it's the government who's restricted. Okay? So now we're going to break this down a little bit. Now, my explanation of that is a little bit oversimplified, but I think you're going to find long term that my explanation that I just gave is right a lot more of the time than a lot of other explanations you're going to hear. So, are there exceptions to what I just said? There are exceptions to everything. This is the law. It's why I never use the word always, and I always say things like likely, because nothing is or is not true in the law. Everything's just probably or unlikely to be true. But I would say my explanation, the one I just gave you, is going to get you where you need to be a lot more frequently than any other explanation you're going to hear. Okay. So, this court appreciates, as the plaintiffs have urged, that several courts to have addressed the issue of non-citizen speech in recent months. Oh, sorry. Oh, hush. Several courts to address this issue have stated in no uncertain terms that non-citizen speech rights are identical to those of citizens. Okay. And thank you for the heart me. I missed it. Sorry. Again, are you ever going to be able to find an exception somewhere? Yeah, you're going to be able to find them, but they're going to be rare. They're going to be narrow, really super narrow. And I'm only saying that not because I know one off the top of my head, hey, Justice, but because I know the law and I know how the law works. And there's always an exception to everything somewhere. You just got to find it. But the court is saying here that what they have found is that the two sets of rights are identical because it's about the government, not the person. Although the court broadly agrees with these analyses, the public officials are not wrong to suggest that the matter is complex. Took the words right out of my mouth. Unlike with citizens, the question involves a collision between two doctrines that do not admit of easy compromise: the plenary power doctrine in the immigration context, and this nation's steadfast and foundational commitment to freedom of speech. What they're saying here, we got two big things that are crashing into each other. One is the power of the government of the executive and the government to control certain things, and the power of, thank you very much, Gerardo, and the power of the of the First Amendment. How the two of those can sometimes be in conflict with each other. Where the Supreme Court acknowledges that First Amendment rights were implicated, but emphasizes the long-standing principle that Congress has plenary power to make policies and rules for the exclusion of aliens, the First Amendment and other portions of the Bill of Rights make no exception in favor of deportation laws or laws enacted pursuant to a plenary power of the government. So, once again, even though, basically they're just saying over and over again, we have two unyielding laws here that are completely contrasting with each other. So how are we going to deal with it? And the answer is, we're just going to sit there and be like, wow, this is complicated. I mean, it's clear, but it's complicated. Which makes no sense. Thanks a lot, Judge. Judicial review of executive branch decision-making with respect to non-citizens is importantly limited in certain contexts, even where recognized rights may be implicated. So, we got to make sure we stay in our lane. Applying rational basis review. Oh, this is okay. Using an example. Another example. They're just listing out a bunch of different examples of times when they had trouble figuring this out, and agreed that it was complicated. Basically, that's what they're doing here. They're just repeating over and over again that this is complicated. Now, I do want to give you guys an example of a time of one spot where I can think of, because it just popped into my head, where 100% I am certain that the First Amendment conflicts with our immigration laws, and we've allowed this to go through, which is that historically we have not allowed self-proclaimed members of the Communist Party to immigrate. Specifically, when another helicopter, or the same one. Specifically, when that word, which I'm gonna not say again because I don't want to get, I never know what's gonna make the algorithm freak out. Specifically, when that word was considered to mean wanted to bring about the fall of the United States. So when those two were considered synonymous, we would say you can't become American because you inherently admit that you want to end America. So we won't let you in. But that was basically one of the few viewpoints that we were like, you aren't allowed. So that was it. Oh, thank you, Breakers. So that's an example that I can think of off the top of my head. And I think if it jumps ahead of me and tells that story right now, I'm going to feel silly. But broadly speaking, the Supreme Court has applied to aliens the same First Amendment test applicable to citizens, with significant exception that citizens generally cannot be deported, obviously. This makes sense of the cases from the early Cold War era relied upon by public officials where anarchist and communist speech and association were sometimes penalized as to citizens and non-citizens alike, although the penalties differed. So what they're saying is that both citizens and non-citizens would get in trouble for saying the same thing. It's just that non-citizens would be deported, citizens would have something else. And here that, they allowed former communist members to be deported. We're going to keep saying that over and over again. They're basically confirming what I just said. See, this is why I shouldn't tell stories, because the judge is going to be right behind me. He's going to say exactly what I say, like a second after me. All right, so and here it is. Here it is, kind of nice and concisely. Is that at the time, being a member, hey, Blue Horizon, being a member of that party was considered to be the same as wanting to overthrow the government by force and violence. So they weren't going to let you join the country if that's what you wanted to do. Have I discussed violating the Hatch Act? I have not, because it's a lot of fact-dependent stuff in there, and until somebody goes through and puts some of those facts down on paper, it's kind of outside of my wheelhouse. I think that's going to happen very soon. It's looking like someone is going to make some formal accusations. Once the accusations are formal and they're written down on paper, I have something I can respond to. But I don't want to start, suggesting legal responses when there's lots of things floating around. So, okay. Some of the most, now we're going to talk about the Red Scare. Basically, that's what they're going to keep talking about. Hey, Christy Crawford, how's it going? They're just going to kind of keep repeating this here. Public officials urge, and this court acknowledges that that particular case has not been expressly overruled by the Supreme Court, even assuming that First Amendment law of the Red Scare era still applies to non-citizens in its entirety. Public officials' reliance on these cases only accentuates two important distinctions between this case and the cases on which they rely. Okay? So the court is saying there is a big distinction between those cases, cases from that era, and this case here. First, that case carefully examined a specific congressional determination that the organization of which the plaintiffs were former members advocated for the incitement to violence. Ultimately, the incitement to violent overthrow of the U.S. government. That had been specifically, Congress had gone through a whole process and done this whole evaluation and said, members of this group have explicitly wanted to overthrow our government, and that's why we're doing this. When it comes to the public perception of a violation of law, do we have an ability to bring a case? Can you give me a more specific question? I know I'm just give me a fact pattern. Give me an example, just so I can be sure I know what you're saying. I have a feeling I do, but I'm bouncing back and forth, so it's a little hard to. Okay, here there is no alleged membership of any organization and no congressional determination specific to it or to the targeted non-citizens, much less a determination that these non-citizens were advocated in overthrowing this government, the violent overthrow of this government. Remember, thank you. Remember that these guys, this all has to do with the situation in the Middle East. These guys had made statements about that situation, so nothing about America at all. And that's why they were being deported. So, second, in these other two cases, which the public officials cite for this, it burdens the non-citizens' First Amendment rights. That all burdens to non-citizens' First Amendment rights are subject to only a facially legitimate and bona fide reason standard review. Hold on, let me try that again. So the cases that they cite for the proposition that all burdens on their rights are subject to... Okay, so the government here is saying that any burden on a non-citizen's First Amendment right only gets this really low level of review. And their evidence for this are these two cases. And I'm trying to figure out... First Amendment rights are standard only a facially bona fide reason, standard of review, are exclusion cases. And the distinction between an alien who has effected an entry into the United States and one who has never entered runs through immigration law. Okay. In any case, political speech is not on its own a facially legitimate reason. Okay, I get it. What they're saying is that, they're saying, they only get this really low level of review. The only level of review they get is that it has to be a facially legitimate reason. But the problem is that political speech, saying that they believe in a particular political issue, is already not, it doesn't pass even that low level of review. That's what the judge says. So even if that were true, it still wouldn't pass. Let me take a moment and ask everybody to tap your screen for a second. We are very low on likes. Sorry, and this is what happens when I get talking. I forget to tell people to tap. Hey, Joe Mac, how's it going? Oh, and yeah, also my morning report mug, if anybody's interested, I think you can get it in my bio, and it helps me keep doing what I'm doing here. All right. So the government may deny entry to aliens altogether for any number of specific reasons, but it may not, consistent with the First Amendment, deny entry solely on account of their speech. So for a bunch of reasons they can do it, but not for that reason. A lawyer in Fort Lauderdale. Excellent. I have a couple of friends one in particular, who is one of my friends from undergrad, is a lawyer in Fort Lauderdale. And I've spent a lot of time in Fort Lauderdale. Fort Lauderdale. All right. So while the executive may exclude an alien for almost any reason, it cannot do so solely because the executive agrees with the content of the alien's speech and therefore wants to prevent an alien from sharing this speech with a willing American audience. And this brings us back to the... This brings us back very specifically to the Alien and Sedition Acts of 1798, which I've talked about extensively, but I'm going to bring this up one more time. There are these 4 acts that were passed in 1798, and they were passed because the government was trying to, well, not the government, the Federalists, very specifically, were trying to kind of push this anti-French sentiment. And they were using this as like among other things, a political rallying point, because the French aristocracy had been overthrown by the rabble, if you will. And as soon as that happened, the Federalists, who had been friends with the French up until that point, because the French had helped us through the Revolution, right? Anybody who's seen Hamilton, we've got Lafayette and Hamilton being friends, and then the next minute, Hamilton's like, oh, screw the French, because now the French aren't the same French we were dealing with a couple of years ago. They're now this other group of French people. The French, the poor people, have overthrown the rich people. And the Federalists wanted nothing to do with it. They wanted nothing to do with that group of people. And so what they said, they passed these 4 laws that, among other things, allowed us to kick French people out and to stop them from speaking, stop them from printing things, stop them from publishing things. And these are called the Alien and Sedition Acts. And they were so unpopular, so very unpopular, that they led the Federalists, who had controlled everything up till that point, to lose all of their control. They lost the presidency. They lost both houses of Congress. They lost everything in the election of 1800. And 3 out of 4 of those bills expired after 2 years. They were overwhelmingly unpopular. And the 4th one, which did not automatically expire, is still with us. And that is the Alien Enemies Act, which is the one that the president has been using with regards to people from El Salvador, right? El Salvador, Venezuela, Venezuela. So, sorry. This is me reminding myself every 15 minutes, so I'm not here for 4 hours like sometimes I will be. Okay. But that is not only is that inherent in our First Amendment law and our First Amendment jurisprudence, but it's really hardwired into 250 years of American ideals. And one of my favorite books. If you can you see, this is why I really love this book. This is Adams v. Jefferson, The Tumultuous Election of 1800 by Furling. What's your name? John Furling. And it's such a good book. But it's all about that election and all of the stuff that was going on with those Alien and Sedition Acts. Great book. Anyway, but I may have gotten a little obsessive with the Post-it notes. And thank you to whoever keeps sending me Post-it notes, because they're getting used. Oh, that reminds me. I'm almost out of white printer paper. If somebody can check my Amazon wish list, I would appreciate it, because I am going to run out of white paper. Sorry, Blue Horizon. Blue Horizon says, stop telling me books, I'm going to go broke. Yeah. I mean, look, this is not the only bookshelf. This is just the one you guys are seeing. There's like 6 of them in this house. I have a real problem when it comes to books. I have stopped myself from going on Amazon or on eBay, because that was really a problem. Because I really, really love the smell of old books. So I would find books that I wanted to read, but also books that were older and I wanted to read, so I could enjoy, like, I love the feeling of them and the smell of them. But they're expensive. Okay. Back to it. All right. So we got this point, I think. You're not allowed to choose this, even at the height of the Red Scare. You still weren't allowed to do this. I kid you not. My dream is Bell's Library. I mean, I really have a book problem. It's not a joke. I want at some point to start building more built-ins, but someday. Okay. Okay. Again, the deportation case, Harsiades, which I should be able to pronounce better. That's a Greek name, and I should be able to pronounce it. Harisiades? Harisiades. Okay. I'll figure that one out. Supreme Court specifically rejected the proposition that the First Amendment allows Congress to make no distinction between advocating change in the existing order by lawful elective processes and advocating change by force and violence. So, rejected the proposition that the First Amendment allows Congress to make no distinction between advocating. Okay. So what they're saying here is that, thank you. Thank you very much, Sarah. Congress, when they're making these laws about immigrants, and they're saying, they're saying they're making rules about who they're letting in, and they're saying, well, we're not letting these people in because they want to change our system here, so we're not going to let them in. The court said here that Congress is not allowed to ignore that one group of people wants to make that change through force and violence, and another group wants to make it through advocating for change and the lawful elective process. If the group of people is speaking and telling people their ideas and they want to convince people to vote a different way, that is always allowed. That you cannot lump them in with people who want to overturn the government through violence and force. That is not the same thing, and the court says you are not allowed to lump those people together. Well, and you say we're seeing that today in live action. Well, this case came out 2 days ago. So now they're looking back, but which rolling was that? Scrolling by, and you said thanks to Sarah. You're welcome. Hey, Sarah. Which rolling? Can you try that again? Which rolling was that? I'm not sure. Okay. So the Supreme Court apprehended the Constitution enjoins upon the court the duty, however difficult, to distinguish between pure political speech and incitement to violence. It is the court's duty to draw that line if nobody else does. So, very, very important. Sarah. Bringing people together. That's what we do here. That's what we do. All right. Ruling. This is, what are we? This is American Association of University Professors v. Rubio. This is the case, and by the way, if you guys haven't seen this is pretty cool. This is what is on the first page. I print every first page in color so I can find them, but this is what's on the first page. And it says, it's a postcard, and it says, Trump has pardons and tanks. What do you have? And the response is, Dear Mr. and Ms. Anonymous, alone I have nothing but my sense of duty. Together, we the people of the United States, you and me, have our magnificent Constitution. Here's how that works out in a specific case. And that is what the judge put at the top of his decision here. So I have never seen a judge do something like that before. And I was a little bit like, wow, that is pretty cool. So that's part of why I wanted to take a look through this. Hey, Danette, how's it going? Make sure that, yeah. And William Young, by the way, is, I believe, a very, very well-respected Reagan appointee who has been on the bench for something like, if I'm not mistaken, William Young, this judge, was appointed when I was in middle school. Maybe elementary school. I think elementary school. So this person has been a judge for a very long time. So this is yeah. All right. Now I lost where I was. Oh, here we go. Okay. Last, it is relevant to this analysis. This court observes, on its face, the First Amendment does not distinguish between citizens and non-citizens. And this brings us back to what I was saying before. The First Amendment, the Constitution, is about the government. It's not about you. It's It's not about you. It tells the government what to do. It tells the government what it can't do. It doesn't tell you what you can or can't do at all. You are not restricted by the U.S. Constitution. Only the federal government is restricted by the Constitution. And so when it comes to who is protected by the U.S. Constitution, that's not really a great question to ask, because everybody in the universe, everybody is protected from the U.S. government by the U.S. Constitution restricting it. The U.S. Constitution restricts the government from doing anything that the U.S. Constitution says it can't do. And that could be anybody who would otherwise have been in its crosshairs. That if the U.S. Constitution says it can't do it, it can't do it. It doesn't matter who the person is. So that's, you got to always remember that the U.S. Constitution is about the government. It's always about the government. That's what it's, and that is not up for discussion. That's why when people talk about, oh, hey, you can't tell me I can't say that. We have a right, freedom of speech in here, or, right to freedom of speech. And that, it always makes me throw whatever I'm holding up in the air, because it has nothing to do with that. I have not talked about the meeting with the military brass because it's kind of outside of my wheelhouse. It might not be outside of my wheelhouse in that I have a whole research project that I have been working on for months that does have to do with that, but I'm nowhere near ready to start talking about it yet. And specifically, it's not in my wheelhouse. But on a broad stage, I may have some big things to say about it, but it's going to take me a while to get there. Again, though, in my shared documents, I have a folder called like National Guard or military or something like that. And somewhere in there is a set of books, 3 PDFs in there that are written by the Army Historical Society, something like that. If anybody wants to read them, they are amazing. They're really interesting. This is in my shared docs. You can get there from my link tree on my profile. Okay, military, and the folder is called History of Military and Domestic Law. It is a 3-part series, each one of which is like 400 pages long. And it is written by the Center of Military History from the U.S. Army. So this is a U.S. Army's own history of how military forces are, not just the history, but the role of federal military forces in domestic disorders. Really got some good stuff in there, guys. Really, really good and very, very topical. And this is the Army's opinion on this. So very much beyond reproach if you guys would like to read it, and it is available. It's not mine. I just downloaded a copy of it off the internet and put it in there if anybody wants to take it and read it, because it's great. It has some really fascinating stuff. It goes back into the discussions from the Constitutional Convention. Hey! All the talking from the Constitutional. It's called The Role of Federal Military Forces in Domestic Disorders, the Army Historical Series. And if you go to my profile and the link in there to scroll down to shared documents, it'll be in the military folder, and it's got a folder called History of Military and Domestic Book or something. And you can find it's 3 PDFs. Great read if you are interested in that topic. And I like I said, it goes through at the beginning all of the, hey, awesome, thanks, Chris. All kinds of inside information about what was discussed at the Constitutional Convention, about how we were going to decide who got what powers were going to be given to the federal government as far as the militias, as far as a central military, all that stuff. Really cool. Having trouble understanding how imposing tariffs falls under AAUP? It's a very good question, and I don't think anybody knows that. We're waiting for an answer. Okay. I will talk about the Hatch Act at some point. I'm waiting for somebody to file something so I can respond to a set of facts on that one. Hey, Jennifer. All right, let me get back to this because I'm trying to get through some of this First Amendment stuff. because I do think this is very important, and I've been waiting to hear something here about the First Amendment. Again, the First Amendment does not distinguish between citizens and non-citizens. It states simply, Congress shall make no law abridging the freedom of speech. Period. End of conversation. Again, it only restricts the government, what the government is allowed to do. And this is objectively, it's just what it says, not my opinion, nothing like that. This is just what it says. And by the way, interpretation changes over time. Again, I can predict the past. I can't predict the future. So things may change, but this is how we've done it in the past. Confirmed. This text at least arguably implies that freedom of speech is accorded aliens residing in this country. It also suggests something a little less obvious, but still worth saying, which is that its chief concern is with the character and quality of the speech that occurs on American soil, which Justice Holmes called free trade in ideas. This is Oliver Wendell Holmes we're talking about here. So, very famous Supreme Court Justice and big writer on the First Amendment. Big First Amendment guy. Which is the best test of truth, according to Oliver Wendell Holmes in Abrams v. U.S. Oh, it's a great case. Oh, there's some really good quotes in Abrams v. U.S. And ensuring that Congress may not twist that speech in the federal government's preferred direction. In other words, as Professor Zachariah Chaffee Jr. puts it, the First Amendment declares a national policy in favor of public discussion of all public questions. The so-called marketplace of ideas. We should be able to talk about things freely to figure out the best answer. The freedom to speak and the freedom to hear are inseparable. They're two sides of the same coin. But the coin itself is the process of thought and discussion. The activity of speakers becoming listeners and becoming... Ooh, hold on. Oh, hush. The activity of speakers becoming listeners and listeners becoming speakers and the vital interchange of thought is the means indispensable to the discovery and spread of political truth. Its protection is a fundamental principle of the American government. The First Amendment means that government has no power to thwart the process of free discussion. So, if you guys, we've been talking for a while, so let me bring it back. What we're talking about here is somebody who was forced or potentially forced to leave because of their opinion on a subject matter. And that subject matter was about how another country in the Middle East, I don't think I need to tell you which one, was behaving. And that is why they were told they had to leave. So this is the question, so there is no question that they were talking about overthrowing our government in any way, shape, or form. Like, there's not even a way to turn what they were saying to say that. Otherwise, we'd probably be having a different discussion. So they were talking about a third party. And that is important. That's an important kind of key point here. So if the First Amendment only applies to the government, why can it be used as a defense to defamation? Because the government is the one who imposes... it's when members of public officials are suing for defamation. The closer you are to being an actual public official, the less protection, the less power you have to enforce a defamation claim, because of the First Amendment. Because we believe specifically that people who are running for office should have their qualities and their activities and their past and history discussed as openly as possible. We give them the least amount of power to sue someone for defamation so that people can say all kinds of things about them without worrying about getting sued. And the closer you are to being an actual public official, the less power you have to sue. The farther you are from that, a fully private person who has never interacted with the public in any way, so-called, your farmer in Kansas, has the strongest power to sue for defamation. Before a newspaper, for example, prints a story about a farmer in Kansas, they better make darn sure their facts are right, because they're dragging somebody kicking and screaming into the public eye. This other person willingly came into the public eye and is serving the public, and therefore we have sort of a right as a public to know about them. That falls under the expectations that officials should expect some criticism. Absolutely, yeah, and it goes back. We're the problem is here a couple of different arguments are getting a little blurry there, so it does get a little bit confusing there. But generally, it's all sort of out of the same idea, and you have to look back to the, I want to say 1600s, 1500s, 1600s, something like that, which is where First Amendment law and where defamation law all come from. They all come from the same spot. And it comes from members of Parliament being allowed to speak freely about each other on the floor of Parliament without being sued. And the idea that if, for example, the Lord, what do you call somebody who's a member of Parliament, but I don't know, Sir Ducky. If Sir Ducky, who is the member of Parliament for North Havingshire, is on the floor and is already elected to Parliament and is therefore protected, MP, thank you, member of Parliament, is allowed to say anything that Lord Ducky or that Sir Ducky wants, and without worrying about libel or slander while on the floor. And Cousin Duckington wants to run against Sir Ducky. It's not fair that only Sir Ducky is protected and can say anything they want about this guy over here who's also trying to run for the same spot. That's not fair. So we started to even out their protections so that they could both run for office with the same protections. And that's what kind of led eventually to our First Amendment and our freedom of speech, this whole idea. But it took a while, and it's a long walk getting there. But that is kind of where it comes from originally, is from this idea. It's called, what are you called? Something. It's something slander. It's not. I want to say libelous slander, but that's not it. It's I can't think of it, but it's it was kind of the original thing, and it all comes from the same thing. This happens to be an area of law that I find really fun and fascinating. And if you haven't noticed, there is a trend. Anything that goes back several hundred years, I start to get more and more interested. But yeah, but that is, why some of these laws get so interesting, is that they're all so rooted in these really old things. Yes, back to the decision. Thank you. Okay. So the freedom to speak and free. Oh, we already did that. Okay. Did I go backwards? All right. Now we're going to go into the standard of review, which I'm actually going to. Oh, actually, this might be important. So the next question is going to be standard of review, and standard of review is important because usually this would be a question about strict scrutiny, right? Because if this is in fact a viewpoint, not a view, a non-viewpoint neutral, a viewpoint discrimination case, then that would get strict scrutiny. But let's see here. What is the standard of review applied here? This court rules that it doesn't have to decide. Ooh. All right. Tell me why, Judge. because even under the facially legitimate and bona fide standard proposed by officials, so even under that ridiculously low standard that they suggested, that all they have to do to get for the court to approve this is to prove that it was facially legitimate, essentially that they were able to spell their names, they still lose, because what they said before is that facially legitimate, which means all they basically have to prove is that this is an immigration question. Like, that would pretty much be the only thing they'd need to prove. But the person's viewpoint is not an immigration question. Thank you very much, Autumn Love. I love it. But they're saying it's not. Even that fails. Even that low, barely a standard fails. The court credited at the motion to dismiss stage that the plaintiff might plausibly be able to show that the implementation of specific executive orders cited amounted to a discrete policy or practice, and that discrete policy or practice targeted political speech. There's nothing unusual in objecting to the implementation of executive orders. Okay. Skip over that for a sec, sorry. At the same time, this court also expressed a related concern that it was not clear the plaintiffs could mount a typical facial First Amendment challenge to an unwritten policy, or alternatively, an as-applied challenge. So they're saying, this wasn't the official policy of anybody. It was just kind of like, yeah, we didn't, we kicked them out because they were saying bad stuff about that country in the Middle East. When those statutes have not been applied to the plaintiffs who are before the court. The plaintiffs here argue that the enforcement actions are viewpoint discriminatory and so unconstitutional all the way down, and they don't need to show intent. On the other hand, the public officials, the government, invoke this thing saying they're not just retaliatory intent, but no probable cause for any adverse action. Sorry, I'm trying to skip to where they get to something. It seems to the court to capture the essence of what the plaintiffs allege. A pair of executive orders. All right, so we have two executive orders that, although couched in a concern for hateful ideology, anti-Semitism, and anti-Semitism harassment, and accompanied by appropriate disclaimers as to the lawfulness of any actions taken in pursuant to them. So even though they said, these two executive orders were supposed to be about kind of a good idea, something worth going after, a good, couched in a concern of a hateful ideology. And that they probably said, it looks like, as many of these executive orders said, for those of you who don't know, they would usually say, do everything you can without breaking the law. They almost all say that. And so I think that's what they're referring to here. And accompanied by disclaimers as to the lawfulness of any actions. In fact, incorporated a definition of anti-Semitism that encompassed protected political speech. So even though this was the plan, they went too far. They made this too broad. Oh, yeah, sorry, will you guys tap the screen for me? And led to singling out of pro one group and anti another group for speech-chilling retribution. And again, I'm trying to avoid using certain words so that I don't get a big red flag and get pulled off the internet. So let's see. Does that make sense? Okay. Basically, the idea is that even though they came at this with all the right words, in practice, it still didn't end up staying inside the law. It still ended up going past what they were allowed to do. This court continues to find that in this case law relied upon by the plaintiffs, helping in guiding its review. Sorry. The plaintiffs have alleged and here proven that the discrete practice of targeting people with this particular viewpoint that is pro one group and anti another group, and that they're speaking about it, which arose from a kind of intentional ratcheting up of the executive order's instructions, while referencing a definition of anti-Semitism that includes protected speech, such as comparing this particular country's policies to that of another country from way back when. On this court's understanding of the law, this is not enough, because some showing of intent on the part of government officials probably is necessary to make out an as-applied First Amendment viewpoint discrimination claim in this case. The plaintiffs have to show that public officials implemented the executive orders was targeted to intentionally chill the speech of specific viewpoints. This court finds that the plaintiffs have made this showing. Oh, okay, all right. Sorry, I was a little bit confused as to what they were saying here. So basically, what they say is that they need to demonstrate that despite what everything said, despite what it looked like they were trying to do, the plaintiffs say that no matter what they claimed they were trying to do, this is what they were actually doing. But the court says, all right, but you actually have to show that they intentionally did that. But the court says, but that's what you did. You guys met that goal. You met that level. The evidence presented at trial included the public officials' many public statements suggesting they wished to stop public protests related to this country's treatment of people in this other place. I hope that's all clear. I'm sorry, guys. I know I'm skipping over some words here. Including the president's campaign promise that he would put an end to student protests on this issue. So the evidence from these other things that he said kind of kicked in to demonstrate that this was intentional, that this is what he wanted to do, that he wanted to chill this speech, that he did not want to allow people to protest or make points about this particular viewpoint. And promising that he would deport and cancel the visas of those who joined these protests. So, okay. So, all of that stuff being on the record didn't help. They may have said, oh, that's not what we did. We didn't do that. But the problem is that the words, the campaign promises, said otherwise. And proved otherwise. So the plaintiffs have proven as the fruits of this investigation. Oh, hush. The plaintiffs have proven. Where'd you go? Plaintiffs proved that as fruits of this investigation percolated up the chain of command, decision makers at every step interpreted support for, I can't say the word, but interpreted the directives of this executive order to mean deporting and revoking the visas of people exercising First Amendment speech related to public protests, leading these protests, or publishing op-eds. Oh, that sound is really is very triggering, right? Everybody knows the sound of the Apple alarm. This review process was essentially frictionless. Okay, so the point is, yeah, basically the facts on the ground just don't coincide with what everybody says they're talking about. So let me see here. The few words that I'm skipping over, lest they are unclear, is that the administration said that they would quell protests against one particular country in the Middle East that has been accused of attacks on another place in the Middle East, or maybe within the same place in the Middle East, whatever. But the other word that I skipped over was the T word, because that is a word that was used in the executive order, which is, screw it, terrorism. Because the executive order said that they were supposed to stop support for that group of people, for people who were committing the T word. And that was construed by administration officials as anybody supporting this movement within the U.S. So, no, sorry, no, not about trans people. We're talking about, that country in the Middle East. That place in the Middle East. That's that stuff. That whole area. Okay. I figure if anything's not going to get me knocked off the algorithm, it's going to be saying those words. And the funny thing is, I'm not even talking. I'm just trying to give the facts of the case. All right. This might seem a matter of recklessness or indifference to how the executive orders ought to be interpreted or what the Constitution requires. But just as a general matter of ignorance, ignorance of the law is no excuse. The Secretary of State and other high officials' apparent indifference to whether support or sympathy for errorism, as opposed to material support, could be grounds for adverse action by law, or whether support could be construed to include voicing support for a group of people, or objection to the policies of a particular country, is no defense to the charge that they've done what they repeatedly said they were doing: intentionally targeting political speech in order to stop campus protests. So, point is that regardless of the issue is sort of irrelevant here. Like, and that's part of the thing. Is, it doesn't matter what the issue is. You're still not allowed to kick people out for protesting about an issue. And particularly, thank you, Beth Luloff, particularly, there has to be a line drawn between what they say here is, where are you? Because that was really good. Where was it? Material support and sympathy. Okay? So they're allowed to be sympathetic towards a group. They're allowed to be supportive in that way, like emotionally supportive. And that is very different from material support for errorism. And that has to be a different thing. This is not an appeals court decision. This is a U.S. District Court for Massachusetts, but this is a final decision, and that's important. Or it's a decision. It's not a preliminary decision. This isn't a preliminary injunction. This isn't equitable relief. This is an actual decision. And so I want to take one more minute here because I'm running out of time. I want to go back to the beginning, you guys, because I think this is really, really important. And I know this is in reverse, so I apologize. But we still don't know about the tariffs. We're still waiting on a final decision there. So I want to read this to you guys again. I have, once again, never in my life seen a judge. Love that. Never seen a judge do something like this before. The judge, I think, everybody seems to know the story except for me. Somebody got this postcard. I'm not sure where the postcard came to. I don't know if it came to the judge. I'm not sure. But this is the postcard, a handwritten postcard right here, okay? And the judge put it right here on top. And it says, 19 June 2025, Trump has pardons and tanks. What do you have? And the judge responds, Dear Mr. or Ms. Anonymous, alone I have nothing but my sense of duty. Together, we the people of the United States, you and me, have our magnificent Constitution. Here's how that works in a specific case. And then the judge gives us this case, okay? Hey, Harambe, how's it going? And then at the end, and this is a Reagan judge who's been around since I was a child. So, and then at the very end, after the signature line, so we've got the signature, signed, William G. Young, okay? We have, and back to the font that was written up here, okay? It says, I hope you found this helpful. Thanks for writing. It shows you care. You should. Sincerely and respectfully, Bill Young. P.S. The next time you're in Boston, and in parentheses it says the postmark on the card is from Philadelphia area, stop in at the courthouse and watch your fellow citizens, sitting as jurors, reach out for justice. It is here and in the courthouses just like this one, both state and federal, spread throughout our land, that our Constitution is most vibrantly alive. For it is well said that where a jury sits, there burns the lamp of liberty. You guys! I'm just I know I cut instead of totally going through the rest of this case because I think we got the idea, but I think this is such a great response. One of the things I've been trying to do through this entire process for the last 9 months is to convince you guys that there is, some of what the legal profession does, and some of the good things that get done every day, despite the bad. Thank you, Manders. I'm glad. Despite all of the, there's plenty of bad actors, and there's plenty of bad decisions, and there's plenty of people who have bad days. Lord knows, I have had plenty of bad days. But that's how you do it. And so when I see a judge like that, who I'm sure has also made decisions that I would not like, but that's how you end. That's how you end a decision. And so I'm just very excited that I sat and read through that, because the end is really. Oh, there's one more little thing here. Freedom is a fragile thing, and it's never more than one generation away from extinction. It is not ours by way of inheritance. It must be fought for and defended constantly by each generation, for it comes only once to a people. So, there we go. You only get freedom once, and you have to fight for it. You have to defend it, and that's what we're doing. All right, guys, that's it for me tonight. Hi, Monica, just in time. But I will be here in the morning with the Aloha Friday morning report. I'm going to be responding to at least this case. I don't know how many more cases I'm going to have because everything's on hold, but I'm going to be filling in on a couple of things, and then we'll be coming in next week and see where we head from there. But I'm definitely going to be quoting that again, because that is just a little bit too great not to. It might be the whole Aloha morning report. I don't know. It might just be me, a cup of coffee, reading that, and possibly sobbing into my coffee. We'll see. All right, everybody, thank you guys so much. I will see you in the morning, and yeah, it's almost the weekend. So, all right, have a great night, everybody. Thanks a lot.